Hello, and thank you to everyone for joining us today. My name is Craig Lawrence. I'm a partner in our Toronto office, and my practice focuses primarily on collective bargaining, grievance arbitrations, union certifications, and work stoppages. I will be your moderator for this session. Today, I am joined by April Kosten, a partner and the head of Denton's Employment and Labor Group in Calgary. April is too modest to say it, but I am not. April is one of the most accomplished advocates in Canada and is the preeminent voice on drug and alcohol testing in the workplace. She's argued many of the leading cases on this issue, including before the Supreme Court of Canada, and we are very fortunate to hear from her today. And with that, I am going to turn it over to April to talk about drug and alcohol testing in Canada for the next 30 minutes or so. And then I will address health and safety in unionized work environments. We'll have about 10 minutes for Q&As. And again, thank you for making time to hear from us today. April, over to you.
Thank you, Craig, and thanks for those kind words. I'm excited to be here today to talk about my favorite topic, drug and alcohol testing, and where things are with respect to the state of the law on issues around workplace alcohol and drug testing. So if we can go to the next slide. So I always like to start off by just talking about the reasons why employers in safety-sensitive work environments need to consider having robust alcohol and drug programs. Occupational health and safety legislation across Canada has very similar provisions requiring employers to address hazards in the workplace, to take steps to eliminate or mitigate them to the best of their ability. There is no doubt that alcohol and drugs in the workplace, fit for work concerns due to alcohol drugs in the workplace are most definitely safety hazards, and occupational health and safety legislation clearly makes it an obligation on employers to take steps to address those. And again, the best way to do that is to have those robust alcohol and drug programs in the workplace. I always like to remind everyone that when it comes to your statutory obligations under occupational health and safety, there is an obligation for employers to take those steps, but there are also obligations on the employees themselves. And I think it's always very important to, as part of your training, to remind employees that they do have those obligations under health and safety legislation. And that includes, in particular, those supervisors or individuals who are monitoring the work and are on the site, making sure that they understand their obligations to, address and limit those hazards. Next slide. Always like to also talk about criminal code liability. There is, potential ability to charge employers under the criminal code when it comes to not taking appropriate steps to address, again, hazards in the workplace. And that includes, again, alcohol and drugs. And this legislation has been in place, this code provision has been in place now for a long time. I will say that it is not used extensively, but when it is used, it does have teeth. So you cannot ignore this liability here. And one of the key decisions that I always go back to that relates to kind of alcohol and drug related issues is this Metron decision, which is now about 10, 11 years old. But this is kind of one of those cases that really is worst case scenario. You've got an employer who is involved in window washing, got 6 employees doing work on one of those swing stages, and only 2 of those 6 individuals are actually wearing harnesses. Unfortunately, the stage collapses and 4 people die. Toxicological analysis is conducted, and it is found that 3 of those individuals did ingest cannabis, including the site supervisor. The employer here was charged for not taking sufficient steps to prevent individuals working who are under the influence of drugs on the project, and the employer was fined. And Again, here, just highlight that originally they were fined $200,000, but on appeal, the Court of Appeal actually upped it significantly to $750,000. So, really, this legislation does have teeth. Liability is pretty significant. Also, just want to highlight that the supervisor who did unfortunately pass away was also charged and was found guilty himself for not taking appropriate steps. So, again, just really important to take into account this legislation when figuring out what steps to take in your workplace. Next slide. So again, where does that leave us with the legislation? Clearly, employers working in safety-sensitive workplaces should have robust alcohol and drug policies in place, including alcohol and drug testing. Taking steps to mitigate and again manage those risks is key, and that includes cannabis in the workplace. I know that since the legalization, it's created a lot of difficulties for employers on how to manage cannabis when it comes to the workplace. Lots of comments from employees saying, well, it's legal now, I can use it, but important to remember that alcohol is also legal. Alcohol has significant risks associated with its use and performing risk-sensitive duties, and cannabis is no different. Next slide. All right, so now we're going to get into types of testing and what may or may not be appropriate for your particular work environment. Next slide. So we've got up here 7 common types of testing, some of them more controversial or reasonable than others. The first listed up there are reasonable cause post-incident, return to work testing, which is following treatment associated with a dependency and having to take a test prior to being cleared to return to work, and then unannounced follow-up testing, which again relates to that individual who has come back to work following treatment and now as part of the monitoring program is subject to unannounced testing for a specified period of time. All 4 of those types of testing have been held as reasonable and appropriate measures to take in a safety-sensitive workplace. As relates to any type of testing, what's really happening is arbitrators are having to conduct a balance between an employer's obligations to ensure a safe work environment against an employee's entitlement to privacy. And that analysis has been conducted. And again, those 4 types of testing have been viewed as reasonable. And really the reason is because in each of those instances, there is a precipitating triggering event that is occurring generally caused by the employee themselves, which then justifies the test. The last 3 I've got on there, pre-employment, pre-access, certification, and random, are the types of testing that are a little bit more controversial depending on the type of work environment you have, and may not automatically be appropriate for every workplace. And it's going to require a bit more of an analysis, which we will get into in the next batch of slides. So if I can go to the next slide. So first, just a little bit on reasonable cause. Reasonable cause and post-incident testing, like I said, are viewed as reasonable, but there's still a lot of arbitral jurisprudence that continues to come out on these types of testing. And it's really addressing the application of the policy, whether or not there in fact was reasonable cause or sufficient post-incident testing, justifying the triggering of the test. So with respect to reasonable cause specifically, this is really all about the employee behaviors. Are they acting out of the ordinary? Are there smells of alcohol or marijuana coming from the individual? Are there signs of alcohol or drug use? That's really what you're looking for. There is obviously no need to have an incident for this type of test. It's really, again, just all about the employee. The one caution I always highlight when it comes to reasonable cause is 99% of the time, you will be conducting an alcohol and drug test when there is reasonable cause. It's obviously very difficult to require your decision makers in terms of who's deciding to conduct a test to figure out whether or not this person is unfit due to alcohol versus drugs. But there are some cases when it comes to the odor factor. If the only reason that you're calling the test is because of a smell of alcohol coming from their breath, there are cases that suggest that you should only conduct an alcohol test, and vice versa when it comes to the odor of marijuana. So just in those circumstances, be careful to think about whether or not you need both types of tests. Next slide. All right, so next, post-incident. Here, always like to start off by saying you don't need reasonable cause here. You don't need the individual that you're testing to appear unfit or impaired. What is really the trigger of the test here is the incident itself. And what you're really looking at is this, a seriousness, a serious level of incident or near miss, enough to justify a test. So paper cut's not going to cut it, but something obviously more is required. The key is really the explanation from the employee. Is there a reasonable explanation as to what the cause of the incident is? If there is a reasonable explanation, then it's very likely testing is not going to be appropriate. However, if there is no reasonable explanation from the employee and it remains very unclear what could have caused the test or could have caused the incident, then a test is likely going to be defensible and appropriate. One thing I always caution on post-incident testing, though, is that doesn't mean you automatically get to test everybody in the vicinity of where the incident took place. You really need to have that link between the specific employee that you're testing and the incident. So for instance, if you've got, a truck full of 4 or 5 employees and there's an accident, you really need to think about, do I actually need to test every person in the vehicle, or am I only needing to test the driver? If you got someone, asleep in the back seat, probably you're not going to need to test them because they have nothing to do with the cause of the incident. Next slide. So here, I always like to highlight the positive wins in terms of cases for employers. This is a non-labor case, but I think results in some useful principles that apply equally to the labor context. So here we had an individual who did test positive for an alcohol and drug test following an incident. The program, the policy that the employer had required, following a positive test, that the individual participate in a substance abuse program to determine whether or not any accommodations are necessary, whether the person has a dependency. The employee just refused and said, no, I'm not going to participate in any of that. It's an invasion of my privacy. It's not going to happen. And the employer terminated based on that lack of cooperation to follow the requirements under the policy. Next slide. Again, this was a win for employer side, and the court really focused on the safety sensitive nature of the workplace and the fact that the policy in those contexts is completely reasonable and appropriate, and failing to comply with those reasonable terms, like requiring them to go for a substance abuse assessment, is justified. And if an employee refuses to cooperate, discipline or termination may be appropriate. So I think, again, this case just really goes towards, there's really useful quotes just talking about the importance and the dangers of cannabis use, whether it's on-site or off-site, if it does have implications in the workplace. And the fact that, employers should be able to follow their own policies when it's being used to address safety concerns. Next slide. So next, just in terms of the pre-employment site access type testing, always just like to highlight that there is a bit of a divide in terms of the reasonableness in Western Canada versus Eastern Canada. Western Canada seems to take a little bit more of a risk management mitigation approach than the Eastern provinces have tended to do. So when it comes to pre-employment pre-access in Alberta, it's generally widely accepted that in safety-sensitive workplaces, it is an appropriate step to take. And that's confirmed in this decision that I have on the screen here, Chasen, as well as if we go to the next slide, the Luca and Lockerbie decision. Now, not so positive in those Eastern provinces. And if we go to the next slide, we've got a decision, which I call the Sarnia decision, which is out of Ontario. And it's dealing with pre-access testing. And here the arbitrator has suggested that you need more than just a safety-sensitive workplace to justify pre-access pre-employment testing, and specifically that you need evidence of a problem with alcohol and drugs. So whether or not you as an employer are thinking about implementing pre-employment or site access testing, definitely important to understand that the defensibility of it and what's needed to justify it is going to depend on kind of where you're geographically located within Canada. Next slide. So that then takes us to random testing, which is definitely the most controversial of all the types of testing. The Supreme Court of Canada stepped in and gave some guidance that applies across Canada as to when random testing may be appropriate in a given work environment. Just having a safety-sensitive work environment is not enough. You will need evidence of enhanced safety risks, such as evidence of a general problem of substance abuse or alcohol and drugs in the workplace. While we have the test, we don't have clear understanding as to what that actually means in terms of how much evidence of a problem is required to defend random alcohol and drug testing. We do know, though, that in Irving, the evidence that was there was 0 positive tests and just eight alcohol-related incidents in 15 years. So we do know that that is not going to be enough evidence. The other piece that I think is important to understand about this test, that I know that many of you who work in safety-sensitive work environments have more than just your bargaining unit employees working on site. You may have contractors as well as non-bargaining unit individuals working on site as well. And sometimes it's very difficult to segregate your evidence of a problem to one group of employees versus another. A Alberta Court of Appeal decision out of Alberta has interpreted what that workplace piece means as set out in the Irving test, and has confirmed that it does mean the entire workplace. It doesn't mean just evidence of a problem with your bargaining unit, because obviously everything that's going on in the workplace is very impactful to the safety risk. So that is some helpful guidance that we do have. Next slide. Another decision that is supportive of random testing is the Phillips and Westcan decision. This is another non-union case, and obviously that is very important to understand. In this case, random testing was in part viewed as reasonable because it was a term or condition of employment of the employee's employment contracts. Obviously, in the union context, that is not going to be the case. But this decision does confirm that to the extent you are able to get it in a collective agreement, which I know is next to impossible, if you do, I think that it will be very much defensible under privacy law and justify the random testing. Next slide. The other piece about the Phillips and Westcan decision that just take note of is that they did consider the Irving test and what was required to justify evidence of a problem. And in that case, the evidence was over a 5-year period, they had a positive random testing rate of 0.44% to 1.79%, and that there was evidence of a vehicle accident, where the individual did test positive for, I believe, alcohol. So there was some evidence there, and in this case, the court did comment that they viewed as enough evidence to demonstrate evidence of a problem. Next slide. Just quickly touch on the most recent random decision we have, came out at the end of 2024, the Federal Court of Appeal, which is the nuclear decision. This was a situation where legislature has stepped in and actually created regulations that require safety critical workers operating under Class 1 nuclear facilities to have a random testing and replacement testing program. This case was really interesting. I was very much waiting to see what happened on this case, simply because a lot of the commentary that you get from arbitrators is, well, if random testing is so important, why doesn't government step in? And here we have a case where they did, and a case where they did, and it was upheld as being justified under the charter. So my hope is that this is going to help other industry groups, try to get random testing, alcohol and drug testing incorporated into other regulations and legislation. But in any event, so this was implemented. Union, not surprisingly, stepped in and argued breach of charter rights. If we go to the next slide. And the Federal Court of Appeal confirmed the prior decision, the federal court, that there was no breach of charter rights. Under Section 7 of the charter, which is the life, liberty, and security of the person, the court found that it wasn't engaged, that this was really relatively non-invasive process, and the fact that there were no automatic disciplinary consequences associated with the positive test meant that this did not rise to the level of seriousness, which appears to be very high, to engage Section 7 protection. Next slide. The section I was most interested in was Section 8, which is the search and seizure section of the charter, which I would say is the most similar to a kind of KVP analysis under labor law, with that balancing of privacy and safety. And here the Federal Court of Appeal said that wait and see approach is not appropriate in this industry. So I think it's very clear the nuclear industry is exceptionally dangerous. The impact of an incident is far-reaching amongst the public environment, more than just employees, and could be catastrophic. But I think it is really helpful here that the court did say you don't need to have evidence of a problem in this situation, that waiting for that first incident isn't necessary. So didn't necessarily follow the Irving test here when it came to looking at the justification of it, of the regulations. Really good quote there under the third bullet. Safety critical workers have diminished expectation of privacy given the nature of their work and unique environment in which the work is being performed. That I think is a quote I'll include in many, many briefs, and is, again, I think just when you're looking at this balancing exercise, there are going to be situations where safety does have to outweigh the privacy interests. And that's exactly what ended up happening when it comes to this analysis. Lastly, Section 15, equality. This was kind of your human rights type analysis, and the Court of Appeal kind of shut that down really quickly. Obviously, this policy was only applying to safety critical workers, but that did not mean that you were creating a distinction on the basis of an enumerated ground of discrimination, that those are kind of two separate issues. So no breach on that section. And then lastly, in terms of the administrative challenge, that was really about, whether or not there was enough due diligence done before taking the step to implement the regulations, and the Federal Court of Appeal found that that was definitely not the case. There's a 10-year consultation process, lots of information gathering done amongst the industry groups and experts, and there was most definitely sufficient due diligence here prior to implementing the regulation. So again, I think this case is unique in terms of the circumstances and the application being nuclear and the fact that there was regulations in place. But again, I'm hopeful that this will hopefully provide some incentive to have, further review about additional industries that should maybe consider having requirements for random and pre-employment alcohol and drug testing. Next slide. So next we're going to talk just a little bit about the human rights side of things, and we can go to the next slide again. Accommodating people with dependencies is incredibly challenging. Most definitely, drug and alcohol dependencies are a disability. They are something that needs to be accommodated to the point of undue hardship. But also at the same time, part of that analysis has to be the safety side of things, and accommodating someone with a dependency in a safety sensitive work environment is going to have incredible challenges that do need to be considered and addressed. Important to know, human rights is only engaged if there is a dependency. So just because you have a casual user or someone who tests positive for alcohol or drugs doesn't automatically mean we're accommodating. A lot of alcohol and drug programs following a positive test do send individuals for a substance abuse assessment to confirm whether or not there is a dependency in play. And then once you have that information, you can then make a decision as to next steps and whether termination or discipline is appropriate, or whether or not you're going to have to take those accommodation steps. Past human rights decisions have confirmed that having policies that are widely known and individuals are trained on, and having a subsequent breach of that policy may justify termination or discipline, even if after the fact the individual comes forward and discloses they have a dependency. The question in those cases is really going to be, firstly, were they well aware of the policy and the requirement to self-disclose in advance of a breach of the policy? And secondly, whether or not that individual had the capacity to understand that they have a dependency and that there was then that obligation to disclose being triggered. So that generally is going to require some sort of expert assessment as to the capacity side of things. But if the individual does have capacity and does breach policy, even though they have a dependency, there may be justification for termination. Next slide. All right, so here we've got just a couple human rights decisions that I want to talk about. The first being this Lower Churchill NIBU decision. It's a 2020 decision from the Newfoundland Court of Appeal. Here we've got a case where the griever did accept employment on a safety sensitive work site, but did disclose that he was using medical marijuana. And the employer decided to send them for a drug test, came back positive, and ultimately refused ongoing employment. This, not surprisingly, resulted in the union grieving. Next slide. Here we had a situation where the arbitrator actually found in favor of the employer's argument that there was no ability to accommodate medical marijuana use in the workplace, and in large part was relying on a suggestion that there aren't a lot of the available technology is not very good at detecting impairment when it comes to medical marijuana, which makes it impossible for the employer to manage. So actually decided to dismiss the grievance. That continued to be the case on judicial review. And then if we go to the next slide, we find that the Court of Appeal actually decided to overturn those decisions. And really the basis of this was the failure of the employer to actually consider and conduct its analysis as to whether or not there could be ways to accommodate the individual. And with respect to that, it kind of goes to the fact that just because you have an individual disclose that they are using medical marijuana, an employer should not automatically say, okay, we can't have it on our site. There needs to be some due diligence. There needs to be some analysis as to whether or not there are ways or other options that could allow the individual to attend work safely. This case is not in any way a case that's saying that automatically medical marijuana use, it's appropriate. You can use it on site, but this case is really all about the fact that the employer just failed to do their due diligence to assess whether or not it could be okay on this site. And with respect to this specific employee. Next slide. So the last decision I've got on here is the Gregg and Canwell building materials decision. This is a 2022 Alberta Human Rights Commission decision, and is really all about the duty to inquire and what can happen if you fail to inquire. All too often, I get phone calls from clients saying that, oh, they've got this employee, he's acting weird. We think he maybe has a dependency, but he hasn't actually told us anything yet. So we'd like to kind of terminate him and nip it in the bud. And I always have to say, well, no, wait. Just because he hasn't formally told you anything does not mean that you can automatically proceed to termination. A human rights legislation protects disabilities as well as perceived disabilities. So you suspecting that someone has a disability, including a dependency, is triggering that obligation to look into it, figure out whether or not the person does in fact have a dependency or not. And in the event that they do, accommodation obligations are going to be triggered. So this decision here really was the opposite of that. You had an individual who was missing a lot of work. If we go to the next slide, he does in fact tell his supervisor that he is an alcoholic 6 weeks prior to the termination, but doesn't really go any further than that. And the employer ultimately decides to terminate him because he's missing work. The missing of the work is obviously very much correlated to the dependency. And so as a result, the termination was viewed as discriminatory. So again, just really important that you do in fact do that due diligence and inquire when there are concerns that someone may be dependent. Next slide. If you go to the last slide, recommendations. So obviously talked about a lot of different things there. And I think the key pieces that really I hope that everyone takes from this is that employers in safety sensitive workplaces really do need to have robust alcohol and drug programs. And really need to train their employees on those programs. I strongly recommend yearly training for all employees, but particularly for those supervisors or individuals who are actually implementing the policy and making the decisions whether or not to go for instance, a reasonable cause or post-incident test. That training is important. The first thing, again, that arbitrators are going to look at when you're defending a test is what training the supervisors had, and also what level of training the employee himself had to understand their obligations under your alcohol and drug program. And then, definitely want to make sure that you don't only implement those types of testing that is appropriate for your particular work environment. Again, random testing, pre-employment, pre-placement's not going to be right for everybody. Really need to make sure that you have the evidence and need for any types of testing that you decide to implement. And yeah, I think that kind of covers the last of it. So thank you. We can go back to Craig.
Thanks very much, April. And again, folks, we encourage you to submit questions on the Q&A, and we're going to try and tackle them at the end of my session here as well. So I'm going to be speaking about health and safety in unionized workplaces. This will be both a broad-based view of what our obligations are, and also a more specific take on, when can we terminate employees for health and safety violations in the workplace. So let's dive right in with the next slide. The basics piece, I think it bears noting at the outset, I'm going to be speaking from an Ontario perspective. The core concepts that we're discussing are portable across Canada, but obviously health and safety is a provincially regulated subject unless you are federally regulated under the Canada Labour Code. But the core concepts are all essentially the same. So when we talk about health and safety in a unionized workplace, I think the starting place really is to understand that the OC Health and Safety Act is incorporated into each collective agreement, whether you reference it or not. There are myriad decisions that stand for that proposition. And management rights extend to the introduction and management of safety policies and practices. And because of that, the specific language of your collective agreement is really paramount on this issue, right? So it's not just about your duty to take all reasonable precautions for the protections of workers. It's not about your obligation to provide safety equipment, sort of the specific obligations under the legislation itself. It's also about how does the collective agreement modify your obligations or enhance those obligations. So understand your CA, in detail. Also understand that this is a tripartite relationship, right? So employees have obligations under legislation. The union has its own obligations to protect workers under our collective agreements. So it's not just about the right to refuse unsafe work. It's also about worker and supervisor obligations to wear appropriate safety equipment, report contraventions of the Act, work in compliance with the Act, and work in compliance with any policies or procedures that we put in place in furtherance of taking reasonable precautions to protect workers. With respect to the Joint Health and Safety Committee specifically, my view on this is be cautious about expanding the mandate of your Joint Health and Safety Committee accidentally. So in some collective agreements, you will find provisions that spell out, well, what's the obligation and duty of the Joint Health and Safety Committee? And in some cases, it's different from how that gets expressed under the Act. And in some cases, it requires the Joint Health and Safety Committee to approve or sign off on policies or changes to policies. And I would caution folks to be really conscious and cautious around abrogating management rights by creating or implementing health and safety policies that delegate those functions to the Joint Health and Safety Committee. So don't, undermine your management rights by giving things away unnecessarily. And also be cautious about, expanding your health and safety liability under your collective agreement. It's one thing for something to be a breach under OSHA, right? Those breaches are generally prosecuted by the Crown through quasi-criminal proceedings. It's another to create freestanding health and safety obligations under your collective agreement that can give rise to its own grounds for damages or remedies under the CA. So again, be cautious and conscious of how your collective agreement is modifying the statutory underpinnings of health and safety. We can go to the next slide here. Talking about introducing health and safety policies and practices. So, as always, there's going to be a distinction between smaller changes and bigger changes. Big changes, in my view, are things that are going to vary existing collective agreement terms. So things that you've already circumscribed, your management rights that are already curtailed by the CA. All right, well, those big changes, you're probably going to have to negotiate them at bargaining because they are not just the consequence of a piece of legislation, they're the consequence of explicit language under your collective agreement. Smaller changes, though, and I say smaller changes perhaps colloquially because The most recent one we sort of have extensive experience with is mask and vaccine mandates. Those changes in health and safety mandates that can be introduced during the life cycle of a collective bargaining agreement. And again, the idea is, what does your collective agreement say about your ability to introduce those policies or change those policies? You know, the most often arguments you're going to see on a policy grievance is either we're attacking this policy on KVP principles, or we think the employer is stopped from making these changes or introducing this policy. So again, just to get on the same page, remember KVP principles, really simple. Every policy that we introduce has to be clear and unequivocal. Every policy needs to be clearly communicated to workers before we rely upon it. That policy needs to clearly anticipate or contemplate discipline, including discharge, being a consequence for noncompliance with the policy. And then the fourth element of the KVP principles, the trickiest of all, have we consistently applied the policy since its introduction, right? And that's usually the foundation for most policy grievances that attack our health and safety initiatives. In some cases, you might face an estoppel argument, right? This idea that we've made a representation that the other party has relied upon to its detriment. Again, a simple example, maybe we actually have some language in our collective agreement that allows for limited testing, drug and alcohol testing in the workplace. Maybe it's post-incidence language, but maybe we haven't relied upon that language with any consistency, or maybe we haven't relied upon it at all. Well, in those cases, there may be an estoppel that prevents the employer from relying upon it going forward, at least until that existing term of the collective agreement is over and the parties can return to bargaining to deal with the issue. But those are usually the bailiwicks under which these challenges are being made. So when we're thinking about these things, we want to be conscious about balancing sort of employee privacy interests and the need for the policy or the practice that we're implementing. A lot of that was touched on by April in her presentation as well. The last piece of this is negotiate with the union. It's there on purpose because negotiate to me is a very scary word. You nearly need to look at your collective agreement and understand what's the extent of your obligation. Advising the union is very different from discussing with the union, which is very different from negotiating with the union, which again is very different from saying you got to obtain consent from the union. So what does your collective agreement say about your obligations when introducing or changing a policy? I hope it doesn't say negotiate with the union. I hope that your collective agreement, restricts that language and keeps your core management rights intact to implement health and safety policies as you see fit. We can jump to the next slide. We're talking about proper documentation. And again, this is something that April touched on in her presentation as well. It's so important to maintain documentation to show what training was provided, to show that specific individuals were provided that training and completed that training, sufficiently and to our satisfaction. Have an online tracking or completion system in place. Keep the training material, even if it's out of date. There's so many, cases that we have argued over the years where we say, look, we've had discrete training on this for the last 10 years. That training material has been updated. But if you don't have the material to show that specific references were being made to certain procedures or certain pieces of equipment, it's really hard to get a witness on the stand who can think back to what training said 8 years ago. So having that material on hand is really quite important. Accidents and near misses need to be investigated and documented carefully. Certain workplace accidents have to be reported to the Ministry of Labor. So that's things like deaths and critical injuries. And the legislation includes definitions for what critical injuries are. So it's not just, where life is in jeopardy. It's something where someone was rendered unconscious. There are, certainly in Ontario, there's injuries that result in a substantial loss of blood. And contrary to what Jake Peralta would say, bleeding that is internal, well, that's probably still a critical injury, right? Even though the blood is, in Jake's words, where it's supposed to be. Things that fracture a leg or that involve consistent burns across a major portion of the body. These are all critical injuries that we have to report to the ministry. And those reports are what trigger that kind of quasi-criminal investigation through the Ministry of Labor. They're going to investigate on their own. They have very broad rights and abilities to both solicit documentation, to sit down with employees and interview them. And ultimately, their responsibility is to determine whether they're going to lay charges or not. So having documented policies, keeping our training material on hand, showing who took that training and when is critical to defending investigations and particularly to defending charges should they be laid. Let's jump to the next slide here. So talking about when will a health and safety violation amount to just cause? I'm going to start from the very high level kind of guiding principles, imperial tobacco stuff, right? It's a tripartite obligation. It's an important concern to workers, employers, and unions alike, and safety violations are very serious workplace offenses. Right? We have a statutory obligation to make sure that work is, done in a safe and secure manner. And workplace misconduct that is deliberate, reckless, negligent, and which results to a safety threat or a perceived safety threat is serious and can be grounds for discipline up to and including termination of employment. And to that point, I would say, again, remember that near misses are still serious incidents, right? There does not have to be a physical injury, actual harm, property damage for some incident to be worthy of discipline, including up to discipline or up to discharge, sorry. Let's jump to the next slide. So again, thinking about when is a health and safety violation going to be just cause? Well, there are always going to be mitigating circumstances as well, and we need to turn our mind to those factors. And I think of them in kind of three buckets. The first bucket is the same things we would look at in any other case of discipline, regardless of whether it has to do with health and safety. What's the individual's record of misconduct? What's their length of service? Was it an isolated incident? Was there provocation, premeditation? Those are all sort of the general bailiwick of how do we exercise our discretion on discipline. Beyond that, we need to be thinking about KVP issues, right? Was the rule uniformly enforced? Was there a misunderstanding? Did the employees understand what the standard was, what the policy said? Those are sort of KVP issues. So they're about the way that the policy was introduced and rolled out and maintained. And then the third one about mitigating circumstances is, was the worker dishonest? Was there, an open and honest display of contrition or remorse? Were they honest in the investigation? And to that end, it's not just about the incident itself. It's about how the worker behaves afterwards. A genuine contrition that's provided immediately after the incident carries a lot more weight than some disingenuous apology that's provided only when they're on the stand 8 months later after they've been terminated, and an arbitrator is trying to determine whether or not this person poses a likely chance of doing the same thing or something just as equally bad in the future. We can jump to the next slide now. A couple of case examples. I'll try to be brief on these. The first one is a decision from arbitrator Sartikowski back in 2013. It's Tonoli, Canada. This is a guy who had 37 years of experience at a lead recycling facility. Lead is a designated substance under OSHA in Ontario, so workers have to wear respirators to limit exposure and prevent inhaling lead dust. You would think this is a pretty reasonable request. In this workplace, the employer actually had to monitor employee blood levels for lead. So again, when you think about the severity of the health issue at play here, even the regulation recognizes that there's a clear tilt toward the health and safety end as opposed to employee privacy. So this griever had 2 serious incidents in 2 days, the last being sort of the final straw. Importantly, again, because he had 37 years of experience, this is someone who had a 25-day suspension 6 months earlier. And on the date of the last incident, he wasn't wearing a respirator mask at all. The day before, he had been wearing it inappropriately because he hasn't been clean shaven. And part of the argument that the worker put forward was, well, look, he didn't put it in these words. These are my words, not the griever's. I'm allowed to be an idiot if I'm the only one who could be hurt, right? He's essentially saying, I didn't put my coworkers at risk. Therefore, my misconduct shouldn't rise to the level of worthy of being terminated. And Sartikowski essentially says, well, that's not the point of health and safety. It's not merely about preventing harm to others. An employer can't contract out of OSHA, even where an employee says, I don't care if I get hurt. So again, the important piece being here, clear rule, clearly communicated, the balance in favor of health and safety clearly outweighs any privacy interests. And there's no reasonable justification for refusing to comply with it. That next case here, the Sudbury Integrated Nickel Mines. This is a guy who had 5 years of service. He's operating a rail trolley, transporting full cars full of ore. He's approaching this curve in the track that has a 6 km/h limit. The trolley and 3 ore cars derail. Amazingly, no one's killed or seriously injured, but the derailment is so violent that it rips up about 100 feet of steel track. And so this is, again, a Sardykowski decision, and he's got to do some back-of-the-envelope math to figure out, how fast this guy was actually going. He eventually concludes the griever was likely doing triple the speed limit when he hits the curve. So we have a clear breach of policy. We have significant property damage. Dismissal is upheld. But Sardykowski focuses on kind of 2 of the elements that we're keen to highlight here. One is that you don't need an injury for it to be a serious incident warranting discipline and dismissal. Again, we have significant property damage here. The fact that he wasn't hurt, that's not a mitigating factor that would warrant some penalty less than discharge. And the second is about honesty and contrition. This is a griever who refused to admit that he was speeding. That's why Sardykowski had to do this back-of-the-envelope math to try and suss out, how fast do I think he was going if this steel rail gets ripped up over 100 feet of ground. So again, behavior after the incident, that lack of contrition, that lack of honesty, is itself oftentimes ground for discipline and dismissal. This last case lacked ill minds. This is a Randall decision, didn't actually highlight how many years of service, but he says he has many years of service. And this is about pattern behavior. So a lot of sort of low-level safety infractions over a significant period of time. The culminating incident in this case was he ran a red light, not a red light, a stop sign rather. Now he ran a stop sign while driving a 150-ton water truck, and there was another vehicle that was entering that same intersection who had to slam on the brakes, skid to a halt. A significant injury would have happened had that person not been able to stop. But the point is, running a stop sign, not always what we think of as a significant safety incident that would ground discipline or discharge. In this case, it did, because we had a pattern of behavior, things like failures to tag in, failures to work in an area without contacting the operator who's in that area. In a safety-sensitive workplace, playing by all of the rules, big or small, does matter quite a bit. We can jump to the next slide here. Again, what are we going to think about before we terminate for just cause? All the same things you would think about, whether it's a health and safety issue or not. Past discipline, culminating incident, what was the damage? We're going to look at our health and safety policies. We're going to look at our training and really ask the question, what can we prove on the evidence about the training that was provided, the policies that were in place, and how they were communicated? And then you're going to prepare for your grievance in any event. And what I often tell clients in relation to that is, think proactively about what evidence you're prepared to share in the grievance process. Do you have video evidence? Are you going to share it in the grievance process? Does your collective agreement require you to do so? Do you have investigation meeting notes with other bargaining unit witnesses? Well, are you going to share that in the grievance process? Are we going to risk having bargaining unit members competing with each other and giving the union an opportunity to perhaps tailor evidence? So these are strategic questions, but ones that you need to turn your mind on early in the process. And the last slide we can turn to here is just about physical fitness testing. We've added it in here because we get a lot of questions about this lately. When can we introduce physical fitness testing? How can we introduce it? Generally speaking, again, we have broad rights to introduce testing requirements that represent legitimate and bona fide requirements of the job. And we can do so long as the tests are not arbitrary or discriminatory or administered unfairly. And all of these cases sort of stand for those propositions. The Durham case was about a stair chair, so the chair that's used to transport patients up and down stairs. Paramedics were required to complete the test on a cyclical basis, and when they came back from a leave of absence, union grieves it. Arbitrator essentially says, look, the requirement to use the stair chair is not new. The test is perhaps new, but nothing in the collective agreement limited the employer's ability to administer physical tests, nor did it require the employer to negotiate with the union before introducing that policy. There is helpful commentary to frame how you think about your testing. It needs to be reliable, it needs to be valid, it needs to be fair, and it needs to be relevant to the work that's being done. In this case, the other sort of important pieces to keep in mind is your physical testing, what's the consequence of it? In most cases where it's being upheld, there's an opportunity to test again upon failure, right? There's an explicit obligation to accommodate anyone with a disability to the point of undue hardship in accordance with the Human Rights Code. In other words, physical physical fitness testing shouldn't be used as a gotcha, right? We're not training Navy SEALs. We're not using incredibly challenging tests as a means of weeding people out. Instead, it's testing that's designed to ensure that workers can actually do legitimate and bona fide requirements of the jobs that they're doing. Rubbermaid, again, sort of stands for this proposition. If your CA doesn't require you to negotiate testing or policies with them, be cautious about how you do it. And Goodyear, similarly, it stands for this idea that, look, if a policy or a practice was introduced years ago and it wasn't objected to at the time, well, employers can also raise estoppel arguments with the union and say, look, this was introduced quite a long time ago. You never objected to it then. There's no basis upon which you can challenge it now. I think I'll stop there because we are going to be running short on time here. Happy to turn to the Q&A. For April, I'll pose it to you. Can you talk a little bit about the degree of effort that was required to get that nuclear regulation model in place and the likelihood that it can be replicated by, smaller industries that perhaps don't have the funding that the nuclear industry enjoys?
Yeah, I mean, that's a good question, Craig. Clearly, to get it in place for nuclear, the effort was incredible. Again, it was an over 10-year process. A lot of experts were canvassed, a lot of lobbying, I will say, was happening, that it is going to be more difficult to get it in place for the smaller industries. I don't think it's without hope, though, because I'm hoping that this was a test case that now will hopefully result in you can kind of work off of what nuclear has done to get it in place for other industries.
I think that's a fair comment. Hope springs eternal, right?
Exactly. Yes.